Tenure protects permanent faculty from being fired or otherwise punished for publicly expressing controversial views. But what about untenured faculty? In Perry v. Sinderman, the United States Supreme Court considered the case of a longtime faculty member whose political views put him on the wrong side of the Board of Regents. Robert Sinderman started teaching in the Texas State College system in 1959. In 1965, he took a job as a professor at Odessa Junior College. He worked there for 4 years under a series of one-year contracts, serving as chairman of the department. Then Sinderman got publicly involved in a political dispute with the college's Board of Regents. At the end of the school year, the Regents declined to offer Sinderman a new contract for the next year. They issued a press release accusing him of insubordination. They didn't explain why his position hadn't been renewed or give him a chance to appeal. Sinderman sued in federal district court, alleging that his contract hadn't been renewed due to his public criticism of the Regents, which violated his freedom of speech, and that the Regents' failure to give him a hearing violated his 14th Amendment guarantee of procedural due process. The Regents and the president of the college denied that they'd fired Sinderman in retaliation for his public criticism of them, and claimed that they had no obligation to provide him a hearing because his contract had ended in May, and the college didn't use the tenure system. The district court granted the Regents' summary judgment. The Court of Appeals reversed. It held that even if Sinderman wasn't tenured, firing him for his protected free speech would violate the 14th Amendment. It also held that failing to give Sinderman a hearing would violate his right to procedural due process if Sinderman could show that he had an expectancy of employment. The United States Supreme Court granted certiorari.